Hello and welcome to Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'll be joined by Chuck James, co-chair of the Mullen White Collar and Investigations practice. How are you doing today, Chuck?
I'm fine. Good to be with you.
Thanks for coming on to the Benefits Companion. I wanted Chuck to join us on the Benefits Companion because from time to time our clients receive nice little letters from the government, from the Department of Labor or the IRS asking questions. And when that happens, the person you really want to talk to is Chuck. And so, Chuck, how does the government seek information from employers? What are the different ways that they may want to obtain information from our clients?
So there's a myriad of ways the government can use, from a relatively informal request for documentation through a civil investigative demand and all the way through a federal grand jury subpoena, which is probably the most constrained and highly regulated form of document production because it has certain requirements that go with it, grand jury secrecy, and tend to indicate a criminal matter as opposed to a civil.
And what would prompt this? Does it mean if you get one of these communications from the government, does it mean you're necessarily in trouble? Or what are the different reasons that one of our clients or an employer would receive a communication from the government seeking information?
So any one of these could be a symbol or a sign, rather, of trouble on the horizon, or it could mean absolutely nothing. Typically, witnesses and our clients fall into one of three categories. They're either a witness, a subject, or a target of an investigation. And a subpoena might be received by any one of those. So the question I have to ask in any engagement is, where does my client fall on that spectrum? And then help them conduct a risk assessment to figure out whether or not they simply have information the government is looking to get that relates to another party, or whether our client really is in the crosshairs and has some significant exposure.
And what I've seen is, sometimes it's just a general audit that the government's conducting, that nothing, there's no complaint or anything, but often an employee or participant under an employee benefit plan has contacted the Department of Labor and said, I'm not getting the benefits I'm entitled to. And that will prompt at least a phone call or an investigation. So you mentioned criminal investigations. What are the different types of federal criminal investigations?
Well, there's a whole myriad, and employers have all the same challenges anyone else engaged in commerce does. You've got potentially disgruntled employees who could raise any number of claims. They could be related to your taxes, your employee benefits plans, immigration status of your employees, and so really employers really need to be prepared to deal with the whole range of issues. There's a special subset that have additional regulation, that is, folks that are dealing with government contracts, because they have all the normal business relationships you would expect in a B2B world, but they have an added layer of exposure given their work with the government and the implications of government contracting.
So what are some of the keys? What are your recommendations to a company that receives a subpoena or an audit request or information request from the government? What are some really top things that they should right off the bat be aware of and do to prepare themselves?
Sure. Well, it's not self-serving, but the first thing to do is lawyer up. It's critically important for clients to engage competent counsel who can look at a subpoena or a civil investigative demand, oftentimes read between the lines as to what the client's exposure is, where appropriate, reach out to the government before the document collection takes place to determine if they're witness, subject, or target, and quite often negotiate the scope of the subpoena or the civil investigative demand. In the world of electronic discovery, things can get very expensive very quickly, and one of the things I typically do very early on is engage the client to figure out how onerous compliance is going to be, and then work with them and with the government to make sure it's as seamless and efficient as possible. And the government, even where they are coming after our client, even if our client is the target, in certain cases can be very accommodating in negotiating an extension of time, document production specifications, or any other sort of things that can really make things smooth sailing for us.
And it's really important that when you respond that it's accurate.
That's correct. One of the worst things about the practice is having to walk back something that you've already presented to the government. And so I work very closely with clients, as I know you do, to make sure that whatever it is we say has been vetted and is accurate, because you are trading on credibility. That's one advantage of engaging counsel, is if you have a measure of credibility with a particular agency or investigator, that can really benefit a client.
And you also don't want the government to claim that you intentionally provided false information.
Sure, it's bad enough if you simply have a mistake where you make a misrepresentation with no ill will. It's a whole different kettle of fish if you are in a position of either willingly or more likely unknowingly passing along information that's not accurate. And so taking the time to engage counsel to get it done right and in a timely fashion is very important.
Is there anything else that a company should be aware of if they're receiving one of these communications?
One thing a lot of clients skip over is document preservation, making sure that anyone who has potentially responsive documents knows to preserve those documents and to suspend a document destruction protocol. Spoliation issues are a big deal, and the government does not look kindly upon that. And then making sure that the documents are collected in a defensible way. And that often requires you to engage a vendor or a third party who has expertise that clients don't have in-house.
Okay, well, that'll wrap up our discussion of responding to government inquiries. I'd like to thank Chuck for joining me today on the Benefits Companion. If you have any questions or suggestions for future episodes of this podcast, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.